Welcome back to the Civil Rights Lawyer channel, where the mission is to not just expose civil rights violations by government officials, but also, and more importantly, to inform and educate individual citizens on their constitutional rights and how to hold those officials accountable in court. Today, I want to tell you about a case that happened in Virginia that's gone all the way through to a jury verdict award. I'll share with you the documents that I've obtained. So this is more than just, look what happened, cops bad. This is showing you the facts, the lawsuit, the court order applying the law to the facts, and also the end result with the jury verdict. I want to share content with you like this with you so that you can educate yourself on your constitutional rights, as well as the process for enforcing them in court. This is the real world stuff that they don't teach you in law school. If you enjoy this sort of content, I encourage you to subscribe, as there's more in the works every day. Today's video is about Matthew Souter, who owns a farmhouse in the Plains, Virginia. He ended up being unlawfully arrested and tased by police officers in his front yard. Stick with me for just a few minutes and I'll tell you about his interaction with the police from the beginning all the way until last week's jury verdict in Alexandria, Virginia in federal court. Back in November of 2018, he rented a bedroom and bathroom in his home to Melissa Johnson. Following a dispute about her cat and apparently an electric hot plate, she went to a local court and obtained an ex parte emergency protective order against Mr. Souter, which restricted him from, quote, acts of violence, force, or threat of criminal offenses resulting in injury to person or property of Ms. Johnson. So the next day, November 10th, 2018, Johnson called the Fauquier, I don't know how I can mess that one up, County Sheriff's Office and reported that the plaintiff had violated the EPO by terminating the electric and water service to her bedroom and bathroom. She spoke with a deputy who took her complaint and classified it as a, quote, civil matter. Not satisfied with that, she called again later the same day, this time speaking with a different deputy who ended up being a defendant in this case, because he was dangerously incompetent. He ended up applying for an arrest warrant against Mr. Souter, alleging that there was a violation of this EPO, when in fact there was no violation, nor any reason for him to believe that Mr. Souter had committed any crime. But he obtained an arrest warrant. So this deputy and his supervisor, and I think one other officer, then traveled to Mr. Souter's home with an arrest warrant. The deputy seized Mr. Souter. I spoke with Mr. Souter on the phone, and he denies resisting this arrest. However, in a subsequent ruling, the federal court wrote that it was undisputed that he resisted arrest. This is what the court found specifically. Plaintiff resisted arrest and did not permit the officers to handcuff him. The officers then wrestled the plaintiff to the ground, while plaintiff continued to resist the officers. McCauley then used, that's the officer, a taser to subdue the plaintiff. After plaintiff was tased, the officers were able to handcuff the plaintiff. So he was tased multiple times, he was bleeding, he was taken to a local hospital emergency room. Now, whether he resisted or not, you'll see what happens with the federal court because the federal judge says it doesn't matter. The officers subsequently charged Souter with the underlying EPO violation as well as attempted fleeing from a law enforcement officer. The EPO charge ended up being dismissed by the prosecutor prior to trial, and then he was found not guilty of the fleeing charge following the criminal trial. Then Souter filed a federal Section 1983 civil lawsuit. You'll find a copy of that complaint at the blog post attached to this video at the blog at thecivilrightslawyer.com. So fast forward in the litigation, and something pretty unusual ended up happening. The federal judge, Judge Ellis, you may have heard of him, in the Eastern District of Virginia, not only denied qualified immunity to the officers, but he granted summary judgment in favor of the plaintiff. That means that the court found that Mr. Souter's civil rights were violated as a matter of law, and that the only issue for the jury to decide at trial is the amount of money to be awarded. So why did the officers here lose qualified immunity, as well as the opportunity to even oppose liability in front of the jury? In short, because they acted with such utter incompetence. The Fourth Amendment protects against citizens being unlawfully arrested by law enforcement. An unlawful arrest is one that occurs in the absence of probable cause. Police officers can be held civilly liable for this sort of unlawful or false arrest if it would have been clear to reasonable officers in their position that they lacked probable cause to arrest. The officers aren't required to be actually correct in their probable cause determination, but just reasonable in their determination. And I'll post the court's full opinion on this matter at the blog post. In this case, all the officers knew is the allegation that the plaintiff had cut off Miss Johnson's water and electric service, allegedly, and he denied that according to his affidavit that was submitted to the court. Now, there was no reasonable basis for them to conclude that Mr. Souter had engaged in any act of violence, force, or threat against Miss Johnson. Thus, if they believed that the plaintiff had done any of those acts, such a belief would have been clearly erroneous and therefore unreasonable. The arrest warrant the officer obtained alleged violation of some domestic violence type of protective order, which didn't even exist in this case. No domestic violence protective order had been issued against the plaintiff, and that would have been obvious on the face of the actual EPO document that had been served on the plaintiff. Moreover, even if the plaintiff had been served with a domestic violence type protective order, cutting off water and electric still does not constitute an act of violence as defined by this EPO. So therefore, the plaintiff's conduct could not have led any reasonable law enforcement officer to conclude that there was probable cause to arrest the plaintiff in this situation. Thus, they violated his constitutional rights when they unlawfully arrested him and then used force to effectuate that arrest in the absence of probable cause. The court held that the illegality of this arrest tainted these police officers' subsequent actions and rendered them liable for using excessive force on the plaintiff when they arrested him. So under federal law, the Fourth Amendment prohibition on unreasonable seizures bars police officers from using excessive force to seize a free citizen. Let's fast forward to the trial results. The jury ended up awarding a total of $50,000 in compensatory damages to Mr. Souter. I obtained a copy of the jury verdict form. I'll post that up on the blog as well. In my phone conversation with Mr. Souter, he was actually very unhappy with this verdict, both in the amount of $50,000 compensation as well as the lack of any punitive damages award from the jury. He took issue with how the presentation of the damages claim was presented to the jury at trial. So for many reasons, people many times have unrealistic expectations on the value of damages that can be awarded or will be awarded or is likely to be awarded in civil rights cases. At the end of the day, a jury decides these things. This can vary wildly depending on a number of factors, including the personalities of the parties, as well as the personalities of the jurors themselves. Now, I wasn't at this trial, obviously, so I have no idea what dynamics were present in the courtroom during the trial. But this illustrates one of the difficult parts of the job of a civil rights lawyer. Ultimately, you have to convince, at the end of the day, a jury to award money damages. And how do you do that? It can be very difficult. It's sometimes emotion or appealing to emotion is all that you have. There's a form instruction in these cases that says something to the effect of, if you find that the plaintiff's civil rights were violated, you must at least award $1, even if you find that the plaintiff suffered no actual damages. So the value of constitutional injuries can vary wildly depending who you have on that jury. But there's also a federal law, 42 U.S.C. section 1988, which provides for an award of reasonable attorney's fees following a finding of liability. This means that even if a jury awards only $1, there could potentially be an attorney fee award of 6 figures. So as always, thanks for watching. You'll find more information in the link below to the blog at thecivilrightslawyer.com. If you have a video you want me to see, please use the submission link in the description or at the blog. If you want to learn more about these cases and about your constitutional rights, please subscribe and hit the bell notification so you don't miss updates or future videos. Please also comment with your thoughts about this case. Do you agree or disagree with the jury's verdict amount in this case? If you want to support the channel, please consider clicking both the join button and becoming a channel member or sponsor. Remember, freedom is scary. Deal with it. I'll see you next time.